My dear, very learned professional colleagues, ladies and gentlemen, adorning the dais, I can say Ma'am Premlata Bansal is always like a motherly figure to me and I have always learnt a lot of very positive and sir, I can remember sir, one of my first appearance in Delhi High Court when I was appearing before Justice Sikri. Opposite me ma'am was there. So there is another special bond ma'am and I always feel enriched when I see the abundant blessings coming from your side to me. And all other my good friends who are sitting here and each one of you, although I have been coming to Chandigarh in the past also and you have, all of you have been very kind enough to bless me in person, sir. And today I have special blessings of one of those personality which I really had very high regard, Honorable Shri Venkatraman Saab. What I say sir about you, when I read your arguments, when I read the way you address the court, I believe any one of me like person can even take 1% of you. I will feel satiated. And I feel blessed that you are here in this gathering. Today the duty which is, and the person who has brought me here, my Goel Bhai, Sandeep Bhai. My real younger brother's name is also Sandeep, and that sense my Mota Bhai's name I can say. Mota Bhai, you understand, Sandeep Goel. So today the duty which is given to me is, sir, to speak on section 148 and 270A and the issues relating to fake invoicing. When Sandeep Bhai gave me this topic, I thought that he is talking about ma'am GST part. So he clarified, no, I have to speak on income tax only. As far as my humble understanding and limited understanding goes, sir, and little understanding, I believe that as far as this subject is concerned, sir, income tax law, and this two topics which is subjects which is given to me about reassessment and penalty. One thing is very clear, that the legislature wants to really make the things simple. There is no doubt about it, sir. There is no centre of doubt. But there is another thing which creates some sort of, what do you say, sir, anxiety or uncertainty in the mind of all the taxpayers, I can say, in humble sense, sir. Due to very discriminatory type of, sir, I'm sorry, type of sometimes stands taken amongst assessees by the revenue department. Maybe in some cases they are absolutely okay, but in majority of the cases, sir, our experience has been, the cases which has come to our chambers, we find that one assessing officer, ma'am, is dropping the proceedings on the same set of cases, and this is a classical case, sir, where section 148, 2 assessment years were reopened. Let us say assessment year 15-16 and assessment year 16-17, ma'am. And for assessment year 15-16, sir, अप्रूवल लेना था चीफ कमिश्नर साहब से मैम, और 16-17 असेसमेंट ईयर के लिए सर अप्रूवल लेना था कमिश्नर साहब से. एंड द सेम assessee, same facts. One case is dropped, another is not dropped, and the case is reaches to the High Court in the writ jurisdiction, sir, which is not dropped, obviously. The question which is begging answer loom large here is, sir, what is the fault of that assessee, that, and what is this left hand do not know what right hand is doing? And there are hundreds of cases where, I again say at the cost of repetition, 148 capital A has been one of the epochal and a mind-blowing provision. There could not have been a better way to recirculate, sir, GK and drive shaft into the law. But the way it is implemented, sir, and I was saying to ASG sir also, the experience which we are carrying is absolutely, sir, not very good. Because majority of the cases, senior professional was here, he gave me a query also, Mr. Mittal. And the point which again comes here over is, sir, that 148 capital A was for the purpose that only deserving cases should go to next stage of 148 stage. But is it really happening? The question is this, that are we doing 148 in that manner with application of mind, that kind of that 148A is done in only in those cases, and the case is treated as fit case, ma'am, in only those cases where it is really fit. Or in a other sense, if I am done under 148A, when I see, sir, department taking this argument in the High Court, that, sir, is very difficult argument, peculiar ma'am argument, and ma'am must be knowing because she is our senior advocate appearing in Delhi High Court. I also have chance to argue there. And there, ma'am, we have seen department taking a stand, sir, that 148 capital A proceedings are summary proceedings, and so assessee files detailed documents, then assessing officer should not be burdened to see all those documents, because he has limited time, and this is 148A proceedings are summary in nature, and only they can be checked in 148. I'm sorry, I asked a question to myself, whether this was the intent of 148A, and this excuse and ruse can be taken, that detailed documents cannot be seen at 148A stage, and they can only be looked at 148 stage, and 148 तो positive होना ही है sir, वो positive test और COVID negative test ऐसा कुछ लग रहा है. I'm sorry. And sir, I have seen those orders where they have written, कि sir, you may have a very good case, Bhatia ji, and in the next stage, they say, you satisfy the revenue authorities in the next stage when assessment will be done, but 148A will be done. Is it not going against the legislative edict? Is it not going against the legislative mandate and legislative intent? In my humble opinion, yes, it is going against the legislative intent, and varieties of cases are there where 148 capital A has been done in those cases where the facts absolutely did not deserve. It was totally a close and shut case, sir. Or in other sense, it is a non-starter. And as I have read as a student, learned as a student of law, sir, that definitely 148 is a power, remedial power. But is it that remedial power that it should be used in every case wherever some financial transaction is done and the amount is high? We have seen hundreds of cases, ma'am, where the excuse given in the 148 is that this taxpayer has purchased this property or has deposited this much amount in the bank account. To verify it, we are doing 148A. And that not in 148 capital A also, my friends will be aware, there are 4 different stages. So clause A, clause B, clause C, clause D. There are 148A में भी सर 4 stages हैं. Clause A के अंदर prior inquiry की बात की हुई है, clause B में show cause notice की बात की हुई है, clause C में reply की बात की हुई है, clause D में order की बात की हुई है. I am no authority, but I can say with all humility, sir, what is happening here, Sandeep bhai? This, sir, ये जो chronology है ना, A में inquiry prior, B में show cause और C में reply और D में order, जो 148 से के ऐतिहासिक प्रोविजन में लिखी हुई, मुझे ऐसा लगता है, बड़ी विनम्रता से मैं कह रहा हूं कि ये अपसाइड डाउन हो गया रोल, कि इंक्वायरी करने के लिए मैडम 148D हो रहा है. एंड आई हैव support of one very important and worth reading order by Calcutta High Court on this point by the pen of Justice T.S. Sivanganam, where, ma'am, the revenue was asking in 148D order and B show cause notice that you give us this details and information. The court asked whether, why not you did 148 capital A clause A inquiry, why you straightway jump to B and D stage? Department had no answer, sir. And the court quashed the 148D order only on the premise that 148 capital A clause A inquiry is not done, and department has straightway jumped to 148A B stage and D stage. There is a question that if you are asking still inquisitorial, you are inquisitive, can you go with the inquisitive mind in 148A D stage, ma'am? And that is happening in lot of orders. They are going in 148D order, sir, with inquisitorial sense. They are not saying that we have some prima facie satisfaction that income has escaped assessment. They say we will still ferret out the things. So, in my understanding, as we have seen, first time Supreme Court has used, sir, in one of the only occasion or rare occasion where the Supreme Court has used Article 142 in the tax jurisprudence, where sir was there in Ashish Agrawal's case, it has both the khatta meeta taste. 444 ITR, page number 1, by the pen of Justice M.R. Shah. Sir assisted the Honorable Supreme Court from the department side. And that is one epochal order where the Supreme Court happens to use Article 142 to save various 90,000 or 9,000, I say 90,000 notices issued by the Income Tax Department. So after that, there has been two types of litigation in MAM 148. One, those cases which are converted cases and which are direct cases. And the dilemma and enigma which comes in every person's mind is that whether we should go in the writ petition against the D order or whether we should go and face the assessment. Ma'am, I leave it at you to conclude it. But my humble submission is this, that it only in those cases you should go in writ where the facts are very, 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 very strong. Because it is our experience, the writ courts, I have at least learned from Delhi High Court Justice Manmohan's court that ideal cases should go to writ petition. That's right point. And secondly, the purpose of 148A is definitely to weed out and to iron out those cases which are not deserving cases. Criteria which was earlier there, Sandeep bhai, in the law has been reason to believe. But now we have a different criteria, information suggesting escapement of income. And now this phrase itself, catchphrase, information suggesting escapement of income. And the caterpillar and catalyst is suggest, which is after information and before escapement of income. And that is defined, information suggesting escapement of income is defined in explanation 1 to section 148. Which is any information uploaded on the system by the department. Sir, there also we are facing a lot of issues that if any information comes to the income tax department, any information, any raw information, any tenuous information, whether it can be the starting point of 148A or not. In my humble opinion, answer should be no. Information should be at least that actionable information which could be the basis to say that yes, prima facie some income has escaped. Assessment, prima facie. But this law has to evolve. Definitely it is in evolution stage. We have not too many judgments which have interpreted the word suggest between the information and an escapement of income. One decision which my learned audience can note, which is worth reading, which has just come, very recent order from Honorable Madras High Court. 50-60 petitions were there, madam, under 148D orders. Sir, this is the order of Madras High Court by Dr. Anita Sumant, Honorable Dr. Justice Anita Sumant. The name of the case is Dr. Matthew Cherian. The date of the order is 1st September 2022. Dr. Matthew Cherian, 1st September 2022, her lordship has taken lot of pain, sir, to go in a very layman style. What is the word information? What is the word suggest? And what is expected in the new law as just opposed to previous law? When they say that there is information which is suggesting escapement of income, what is required by the AO to be done? There they say कि ऐसा information तो कुछ होना ही होगा सर जिससे कुछ ना कुछ income escaping assessment के गुण निकल रहे हैं. कोई भी raw information के base पे नहीं कर सकते. She has made the order very good by elaborating her reasoning कि why the word suggest is very critical word here, sir. And she has squashed the at least 30-40 writ होंगे मैम इसमें इसी cases में, and they were cases of all doctors, and there was some issue कि सर ये professional है या ये salaried में assess होना चाहिए. There was that old controversy कि they were doctor engaged with some hospitals कि इनकी income किस head में assessable है. So the judge also said कि if department is using 148AD against the settled judicial principles, then writ court can interfere and should interfere. Although इस पे भी अभी सर अभी आर्ग्यूमेंट्स चल ही रहे हैं, बहुत सारा हाई कोर्ट्स तो ये भी कह रहा है, जैसे मध्य प्रदेश हाई कोर्ट का भी जजमेंट 1 सितंबर का ही ऑर्डर है वो भी. Sir, Madhya Pradesh High Court has taken a view that no writ should be entertained against 148AD order because Madhya Pradesh High Court believes, Honorable Madhya Pradesh High Court, that this is a tentative preliminary order, interlocutory order, and no writ should be admissible. This is also one school of thought coming from, at least my knowledge says, कि Madhya Pradesh High Court and Telangana High Court. again, with all humility, although I'm no authority to say, but this is definitely a point which needs further pondering, ki sir, whether order passed under section 148A clause D is an interlocutory order or it determines very important rights and liabilities of the taxpayer. 148 की डी के ऑर्डर से मुझे तो सर मेरा हम्बल ओपिनियन है कि उसमें तो बहुत सारे अधिकार और लाइबिलिटीज असेसी के सुनिश्चित हो जाते हैं. मुझे 148 की रिटर्न भरनी पड़ेगी, असेसिंग ऑफिसर के सामने जाकर अपना कर निर्धारण कराना पड़ेगा और अपने ये खुद मेरे पे ओनस भी आ जाएगा कि मैं साबित करूं कि इनकम एस्केपिंग असेसमेंट नहीं है. तो मैंने जस्टिस चंद्रचूड़ साहब का, ऑनरेबल जस्टिस चंद्रचूड़ साहब के सर 2 ऑर्डर आई फाउंड फ्रॉम द लेटेस्ट ऑर्डर्स व्हिच यू ऑल कैन नोट, where this issue ki how and when you say an order is an interlocutory order, this is no long, this should be a no longer interlocutory, and there they have said in this order of where I have noted, just a minute, this is the name of the case is Manjeet Singh Sodha versus Custodian. This is the order by Justice Chandrachud, Honorable Supreme Court order, sir, latest order of September and October 2022. And ma'am, the test which is given by the Supreme Court, Justice Chandrachud Sahab, is that whether that order is determining the important rights and liabilities of the assessee. In my humble opinion, 148D order is definitely having determination on the assessee's important rights and liabilities. In so far as my liability to file return, in so far as my liability to face the tax assessment, in so far as my onus to say that there is no income escaping assessment. So the view of Madhya Pradesh High Court and Telangana High Court that these are tentative orders or interlocutory orders or preliminary orders, in my respectful submission, is not correct and requires reconsideration. Another part which is, sir, I say, ma'am, lot of cases where 148D order was passed, जिनमें बहुत सारे cases में 148 AD हो गया सर, और अभी 148 का assessment होना है. एक बड़ी विचित्र चीज सर सामने आई, बड़ी peculiar चीज, कि वहां डिपार्टमेंट के सारे ऑफिसर्स, ज्यादातर ऑफिसर्स का ओपिनियन ये है कि 148D अगर एक बार हो गया सर, और उसमें डिपार्टमेंट हैज ट्रीटेड माय केस एज ए फिट केस फॉर 148, दे से वी विल नॉट हैव एनी रूल रीलुक एट दैट पॉइंट कि जो अगर if I can say, ma'am, let us say 148AD is passed on some ground that my income has escaped assessment because I have deposited cash in my bank account. And supposingly, I satisfy now in the assessment also that there is no cash, there is no escapement of income qua that point. Whether he can go on to other issues or not, or whether he can give me general questionnaire which they are giving, ma'am. In all the cases, they are giving general questionnaire as if 148AD के बाद तो वो चीज खत्म हो गया है. I repeat my question. It's a very serious question. I have to write to so many points to understand it कि what is going. 148AD का ऑर्डर हुआ एसएससी का सर, और उसमें डिपार्टमेंट बोलता है कि साहब इनकम एस्केपिंग असेसमेंट है सर, और अभी मेरे को 148 मैम चालू हो गया मेरा असेसमेंट. Is not the assessee allowed to say that 148AD itself is wrong and so proceeding should be dropped? Or just because 148AD order is passed, that stage is gone and assessee's right to challenge 148AD in the assessment goes away? Sir, I recall one doctrine which we read when we were students, sub lato fundamento carried opus. That is when foundation fails, superstructure falls. There is a decision of the Supreme Court, a locus classicus, Devender Singh Bhullar versus State of Punjab. Devender Singh Bhullar versus State of Punjab, a leading citation, 2011, 14 SCC 770. 2011, 14 SCC 770. The lordships have held, if initial action is wrong, then all subsequent actions goes. So, I don't know, sir, how I ask a question to myself again. If foundational facts are wrong in 148AD and I can prove it in the 148 trial and adjudication, can they say, no, we will still go on to the general issues and general questionnaire in the garb that it is a de novo assessment? I'm sorry, in my respectful submission, it is not a ma'am de novo assessment. Section 147 explanation they might go, that the law permits them to go into the other issues also, but that is in a very limited circumstance. That explanation is not like this that makes 148 as a de novo and a fresh assessment. It has to be co-a that 148AD order first. If foundation of 148AD goes, ma'am, in my respectful submission, then entire 148, and nobody can say, somebody asked me, sir, a senior chartered accountant, कि Mr. Goel 148AD का order तो approval से pass हुआ है higher authority के, चीफ कमिश्नर साहब के, कमिश्नर साहब के, उसको कौन 148 के ऑर्डर में छोड़ेगा? I'm sorry, this is not the way I look at it. I believe 148AD का ऑर्डर, मैडम, अगर डिपार्टमेंट खुद बोलता है कई जगह रिट में कि टेंटेटिव है, तो what can prohibit the assessee to show that 148 AD order has no legs and legal legs to stand. I believe, sir, I can even challenge it in the ITAT and CITP when the case will go. 148 AD order, if it is passed on wrong facts, if it has having no legal foundation and proper foundation, then it can be agitated and repudiated in the assessment also. Definitely, these are the points which will be further evolved in the course of the litigation which we are having, sir. One thing, another practical thing, ma'am, which I found in at least मेरे chamber में मेरे पास 3-4 litigation सर ऐसे आए जहाँ पर permanent account number became the basis of 148. And I will make my point good. assessee ने किसी जमाने में एक पेन नंबर ले लिया सर गलती से, और उसको बाद में समझ लगी मैडम शुद्ध आई जैसे बोध हुआ कि नहीं मैंने गलत किया है, आई शुड नॉट हैव 2 पेन नंबर्स, दिस इज रॉन्ग. उसने अपने आप पेन नंबर सरेंडर भी कर दिया सर और डीएक्टिवेट भी करा लिया. जिन अधिकारी से जिनके पास असेस होते हैं उनको लेटर लिख दिया कि मैं पेन सरेंडर कर रहा हूं, मेरे पास 2 पेन थे, आप इसको डीएक्टिवेट कर दीजिए, और विभाग ने एसएससी को चिट्ठी लिख दी, हाँ आपका ये पेन नंबर डीएक्टिवेट हो गया. और ये 4-5 साल पहले हो चुका मैम. और आज उसी पेन नंबर के ऊपर डी का ऑर्डर एस्केपमेंट का 15-20 करोड़ का पास हो जाता है, सब कुछ उसी पेन नंबर पे जो सरेंडर और डीएक्टिवेटेड है. डेफिनेटली आई गॉट द रिलीफ सर. इस केस पे मुझे जस्टिस मनमोहन साहब ने दिल्ली हाईकोर्ट ने रिलीफ दे दिया, हालांकि सेटिस्फाइड किया उन्होंने केस को, बट उन्होंने कहा यस इट्स रॉन्ग. अल्टीमेटली सर एसएससी के पास जो करेक्ट पेन था उस पर वो सारा कंप्लायंस कर रहा था, देयर वाज नो फैक्चुअल एस्केपमेंट. सर डिपार्टमेंट के पास जब एसएससी गया सर, कैन यू इमेजिन व्हाट दे से कि नहीं भैया हमारे यहां तो रॉन्ग पेन नंबर अभी भी है, हम इसको माइग्रेट ऐसा नहीं कर सकते. वो एसएससी ने बोला सर कि मैं तो रिटर्न भर रहा हूं साहब, और मेरा सब कुछ रिटर्न में दिखाया हुआ और एक करेक्ट पेन नंबर है, आप मेरे से 2 बार टैक्स सुना लेंगे. वो कह रहे नथिंग डूइंग. हमारा चीफ कमिश्नर साहब ने बोला केस खोल दो. फिर ऐसा होगा तो मैम फिर देन आई हैव नो व्हाट्स टू से. सो इफ इट इज, आई एम सॉरी विद ऑल द रिस्पेक्ट, और ये सब बातें जब हमें पता चलती हैं कि सर जब हम ऑर्डर शीट मांगने डिपार्टमेंट के पास, सर इसके अंदर जब हमने डिपार्टमेंट से ऑर्डर शीट मांगा इन प्रोसीडिंग का सर, उन्होंने हमारे को ऑर्डर शीट मैडम पहले देने से मना कर दिया कि हम प्रोसीडिंग शीट नहीं देंगे, कि 148 का प्रोसीडिंग शीट कहां लिखा है, देना लिखा है. बट आई बिलीव वी हैव बीन टॉट फ्रॉम क्लास 1 नर्सरी कि दैट प्रिंसिपल ऑफ फेयरनेस एंड ट्रांसपेरेंसी, ऑर्डर शीट ऑफ 148 आर नॉट कॉन्फिडेंशियल डॉक्यूमेंट. And I am not wasting your time. You can note the suggestion if you like. In all those cases where 148A you find it is done in wrong circumstance, the assessee's right to get the copy of the order sheet of 148A must be done. And one more thing here, the recommendation of the AO and the approval of the CIT should also be seen in what manner they have done the proceedings. I was telling sir when sir I came with him only. One classical case that came out from order sheet only, sir. अगर वो मुझे order sheet नहीं मिलता तो मुझे पता ही नहीं चलता कि ऐसा भी हुआ है या हो सकता है कि जहां assessing officer madam 3 times wrote in the order sheet that it is not a fit case and commissioner साहब believe कि no it is a fit case, you take the case for 148. It is another legal question कि whether this can be legally valid or not, but my point is this कि how the proceedings have been conducted madam has to be at least fairly and transparently told to the taxpayer. Because you can't say that it is matter of internal communication, it is internal document, assessee has no right on these documents. I'm sorry. Sir will appreciate, sir. Justice Chandrachud written an epochal order, and this order is my favorite order, sir. And this order he has applied, I believe, latestly also in a sealed cover matter. This is an order by Justice Chandrachud in the case of T. Tikanu versus Securities Exchange Board of India. T. Tikanu, ma'am, worth on reading, it's a magnum opus. T. Tikanu versus Securities Exchange Board of India. That what is the relevance of principle of fairness and transparency when it comes to sharing of the some kind of information, and it applies in my humble opinion to income tax also and 148A also. And sir, some South High Courts, I read the order of Justice C. Parveen Kumar of Andhra Pradesh High Court, where he has applied his lordship this T. Tikanu order in some of the matters to quash the proceedings in the tax laws. So this T. Tikanu order, Supreme Court itself, sir, 4 or 5 orders they have reapplied. So it simply says that whatever is relevant must be given to the affected person so that he can rebut it if he so wants. So, and other, I should always admit, as my good seniors always say me, that Mr. Goel, while criticizing 148A, why not you appreciate that you are getting so much of work from 148? I always appreciate it. But there is a academic hurt, ma'am, always going on. That when we see from academic sense, that thing come from our mind, howsoever we want to stop it. That it is right or, and when we say it is right or wrong, we see, sir, it is as a constitution student. Whether it is as per principles of those Article 14 and Article 265. And whether or not they are arbitrary and in principle with law, sir. Everything cannot be under 148. Everything cannot be income escaping assessment. Every financial transaction, contra transaction, bank transactions cannot be 148. And even today it is not roving inquiry and fishing inquiry. Nobody can say, sir. At least it is reopening my settled assessment, and those words of Justice H.R. Khanna, my seniors have told me, sir, that Justice Khanna's order in Parshuram Pottery is 106 ITR page 1 last paragraph. There should be some point of finality in all the proceedings. I wish that happens in 148A. Those chaste words of Justice H.R. Khanna, his lordships in Parshuram Potteries, that Ekpokal order 106 ITR page 1 last paragraph. There must be some point of finality in all the proceedings, and stale issues must not be reopened beyond a point in time. That dictum, in my humble opinion, still holds good, ma'am. So 148A, when disturbing the finality of a concluded assessment, so it should be seen in that light. Sir, it should not be seen in that light as if, what is the problem to the taxpayer to have the assessment? For that 143 too is there. 148 is not security assessment in my humble understanding. 148 and 143 too are not analogous and paramateria. So, as far as 148 capital A is concerned, sir, as I have already told, some high courts have, sir, dismissed the writs in limine, some high courts have admitted it, some high courts are going case to case. Our Delhi High Court is going on case to case basis. In deserving cases they are admitting the writ, and in they are not following. They are not allowing. So call has to be taken by the assessee, sir. And in the converted cases, sir, that post Ashish Agrawal, there is a special problem now. Due to that, sir, with due respect to CBDT and that instruction. That assessment year 13-14, assessment year 14-15 and assessment year 15-16 are time barred or not into the. According to, sir, it is. Sir, I would have gone by your sage advice, but I am doubtful my other friends will go like that because humbly, sir, humbly put, because now what has happened, although our Delhi High Court has confirmed the position that in Touchstone Limited case and Salil Gulati's case, that these are not time barred, but Rajasthan High Court Justice M.M. Srivastava has passed a very detailed order in Geeta Rani Agarwal, that is 11th October 2022, where Rajasthan High Court has taken sir stand and a very detailed interim order of 10 pages. It's interim order, but it's very detailed order after Ashish Agrawal. They say that what is time barred under 149(1)(b) first proviso cannot be reincarnated due to this thing. Anyhow, sir is saying that it is not time barred. But yes, definitely, sir. For me, you are saying it is very important, sir. Sir. No, but Bhatia, definitely that is for the court only. That when this already, in my humble opinion, Justice Dheeraj Singh Thakur in Bombay High Court has admitted 1,000 writ petitions, giving en bloc stay, sir, in all these cases. I am saying on record. Punjab, but the scale of Sandeep Bhai in the Bombay High Court, sir, Justice Dheeraj Singh Thakur's court. I am in one India point, sir. See, ma'am, the point is this, there the Bombay High Court has preliminary also taken the point that this assessment year 13, 14, 15, 15, 16, subject to what sir is saying, that they are time barred and they have granted stays, although the final hearing, sir, is yet to take place. There is another, and with due all humility at my command, sir, I would beg to differ from sir, that in my plain reading, as per the legislative intent behind this new law 149(1)(b), sir, there was nowhere it was in the mind that these proceedings, madam, has to be saved. As Justice Akil Qureshi, sir, wrote one decision in Rajasthan High Court, sir, I am speaking from there, para 37, para 38 of Sudesh Taneja's. He has written, and my statement is supported by Sudesh Taneja, ma'am, Rajasthan High Court decision of Justice Akil Qureshi, where the interpretation given to 149(1)(b) first proviso tallies with the assessee's opinion and submission that this AY 13, 14, 14, 15 and even 15, 16 are time barred. But yes, as Bhatia sir has rightly said, and good other good friend Sandeep bhai that this is a matter now have to be resolved, because again this is a second round of litigation and various courts are already, constitutional courts are of seized of it. इसी में एक और सर पॉइंट है, आप सबने देखा भी होगा, असेसमेंट ईयर 16-17 का और असेसमेंट ईयर 17-18 का। सर इसमें भी एक कैच है सर, डिपार्टमेंट बोलता है 16-17 का केस हम आज रीओपन करेंगे मैम 3 साल के बाद, तो अप्रूवल लेंगे कमिश्नर का। हाउ इज इट हैपनिंग? हाउ असेसमेंट ईयर 16-17 रीओपन टुडे इन 2022? इट इज विदिन 3 years। मैं आई रिकॉल ऑल ऑफ यू कि अभी नया का लॉ में क्या लिखा है सर कि 3 साल के अंदर केस रीओपन होगा तो अप्रूवल चाहिए सीआईटी का, और 3 साल के बाद मैम चीफ कमिश्नर का। तो आज मेरा आप नए लॉ में जब नोटिस दे रहे हैं और असेसमेंट ईयर इन्वॉल्व 16-17 है, आज का मतलब जुलाई 2022 में, तो इट इज इनवेरिएबली आफ्टर 3 years and approval is not taken from chief commissioner, approval is taken from commissioner. So various high courts in my understanding, especially Bombay High Court and Allahabad High Court, have taken again very serious note of this point that whether TOLA and all these things can extend the change the status of the authority also, or they can alter who is the competent authority under 151 section 151 sir. The competent authority to give the approval after 3 years, in my respectful submission, it should be chief commissioner. But yes, this issue is also very much hotly debated, contested, very widely argued. And as वो सर जेएम फाइनेंशियल वाला केस के अंदर सर इज वो बॉम्बे हाई कोर्ट वाला असेसमेंट ईयर 15-16 केस 1 SLP notice sir, yes you are right, JM Financials case sir, that Justice KR Shriram in Bombay High Court wrote. But again I have my own humble understanding ma'am that 151 is very plain कि if within 3 years reopening is made, the approving authority has to be CIT, and after 3 years the approving authority has to be chief commissioner, and it has to be plainly applied. It cannot be mixed and coalesced with TOLA in my humble submission. So I believe I have covered 148 part. Finally, there are 2 judgments or 2 important landmark orders which have been favoring assessee sir, and that is, and they have become very favorite with the taxpayers ma'am. There is Allahabad High Court decision where 50 lakh cost was Justice Keshan Wani imposed in the case of SR Cold Storage. That citation is 448 ITR page number 37, 448 ITR panna number 37. The issue there was the reopening made on non-existing and wrong facts. An assessment was reopened sir saying assessee का इस बैंक में इतना पैसा जमा हुआ है, बाद में मैडम डिपार्टमेंट ने मान लिया कि वो पैसा उस बैंक में असेसी का अकाउंट भी नहीं है और उतना पैसा जमा भी नहीं हुआ, और उसका असेसमेंट भी हो गया गोयल साहब, उसको सर उसका एडिशन भी कर दिया। तो वो असेसमेंट होने के बाद रिट में गया। पहले तो डिपार्टमेंट का ऑब्जेक्शन ये आया कि साहब ये असेसमेंट के बाद रिट में क्यों आए, तो अल्टरनेट रेमेडी में जाए। तो जज साहब ने डिपार्टमेंट से ही पूछा कि साहब आपको इस फैक्ट्स पे डिस्प्यूट है क्या, कि ये जो बोल रहे हैं कि ये आपका जो रीओपनिंग का फैक्ट्स था वो सब फाउंडेशनल फैक्ट्स ही गलत था, रॉन्ग फैक्ट्स था, नॉन एग्जिस्टिंग फैक्ट्स था। डिपार्टमेंट ने कहा नहीं ये फैक्ट सही है। तो then Justice Kesharmani ma'am wrote one paragraph that argument of alternate remedy cannot come in the way of the assessee because this is not a question of disputed fact. And revenue admits that the reopening has been made on wrong facts, erroneous facts, non-existing facts. And I believe it's a what a order which we cherish. And what an order, sir. They quashed it and must be quashed, sir. And that part is definitely an accountability part and all those things which he has written. I was otherwise comparing this judgment with the judgment of Justice Arvind Kumar, the Chief Justice of Gujarat High Court, a very latest order argued by Sorparkar Sahab, where again the foundational facts were proven to be wrong by the assessee sir, that जिस बेस पे आप reopen कर रहे हैं वो तो facts ही आपने गलत लिखा है। तो ऐसा बहुत सारा मैडम केसेस हैं जहां पर हमारे पास वो 148D भी आया, उसके फाउंडेशनल फैक्ट्स गलत है, तो वहां एसआर कोल्ड स्टोरेज 448 ITR 37 you can note. I will not bore you more than that. Second, there is another decision sir, maybe it will reach to Supreme Court very easy, early, और हो सकता है पहुंच भी गया हो सर. That is the case of Vikas Gupta, and please note the citation of it, 448 ITR page 1 sir, 448 ITR page 1. एंड मैम ये इस केस से मेरा थोड़ा सा इसलिए लगाव ज्यादा है कि ये रिट मैंने बनाई थी, आर्ग्यू मैंने नहीं करी, पर ये रिट मैंने ड्राफ्ट करी थी, और इसमें विषय इतना इंटरेस्टिंग था, और हमारे जो दिल्ली के दोस्त हैं और भी लोग इसको अप्रिशिएट करेंगे बात को, कि भाटिया जी एक असेसिंग ऑफिसर ने एक 148 दिया और उसमें रीजंस रिकॉर्ड किए, लेटर से 30 मार्च 31 को मैम, या 148 का नोटिस 31 मार्च 21 को दिया, शाम को 5 बजे का उस पर डिजिटल सिग्नेचर लगा हुआ है, और जो अप्रूविंग अथॉरिटी है जिसने अप्रूवल दी सेक्शन 151 की, जो पहले होनी है नोटिस है संदीप जी, उस पे जो डिजिटल सिग्नेचर लगा हुआ है वो नोटिस के बाद का है, 31 तारीख का ही है, पर टाइम बाद का है। तो क्वेश्चन यह है सर, पहला तो ये बिल्कुल एलिमेंट्री कि 151 अप्रूवल हैज टू बी प्रायर टू 140 नोटिस, में तो किसी को डाउट नहीं है। अब क्वेश्चन ये कि जो नोटिस 148 का नए जमाने में, मैम आज के जमाने में इशू हो रहा है, जिस पे डिजिटल सिग्नेचर एक पर्टिकुलर टाइम लिखा हुआ है, और कंपैरेटिवली जो अप्रूवल 151 में आ रही है उसके ऊपर टाइम बाद का लिखा हुआ है, इज इट इन अकॉर्डेंस विद लॉ और नॉट? डिपार्टमेंट से सर वहां पर भी जो एएसडी साहब हैं, सिंह साहब, वो अपीयर हुए, उन्होंने कहा नहीं हमारा ये, गवर्नमेंट का आर्गुमेंट ये था मैम कि जो हमने अपने इंटरनल सिस्टम में कमिश्नर साहब ने अप्रूवल पहले दे दिया था नोटिस से, ये जो फाइनल अप्रूवल साइन हुआ है ये बाद में, और साइन करने का अलग से कोई जरूरत नहीं है। एज पर लॉ ऑफ सेक्शन 282A, द प्रोविजन व्हिच डिपार्टमेंट took shelter was 282 capital A. You may get note this provision. It's very important section which department is using in some of the litigations now. And now what Justice Kesharwani said, no, sign is must even after 282A, ma'am. And if sign is by the commissioner after the date and time of the notice, then proceedings are void ab initio. So maybe as ASG Saab is sitting here, this Vikas Gupta's case on 282A has a, sir, very fine implication. I believe the time. Yes, sir. I will just wind up. No, sir. I'm just winding a 5 minute, sir. Ma'am, 5-10 minutes. Should I take more? How much is the time? Yes, just 5 minutes more. I will wind up. Because my second, I knew ma'am had already told me that both the topics could know. Yes, ma'am. Okay. As our what I say, septuagenarian and very respected Goel sahab has asked me that yes sir, Punjab and High Court recently in some of the matters decided under section 148A by the bench of Justice Dhindsa sahab has taken a view that writ should not be admitted against the order passed under 148AD. But as I say sir, there are two things, two scholastic principles, sir. One is this, that if there is a central legislation and there is a particular CBDT, even CBDT believes that 148A should not be done in a light-hearted way. Now CBDT also recognizes after SR cold storage. So to throw the writ in limine is not the right thing, especially when there are gross irregularities and illegalities in the decision-making process. As we have learned in judicial review is defined as when there are serious errors in the decision-making process, may it be irrationality, may it be illegality, may it be impropriety, etc. So, if there are apparent, glaring, patent illegalities and irregularities in the decision-making process under 148A, then in my respectful submission, sir, writ should be entertained, and that is what Delhi High Court and Bombay High Court, Allahabad High Court, other High Courts are doing. Sir, as far as that point is concerned, that what your good self is mentioning, Anshul Jain's case, where Justice M.R. Shah in one of the cases coming from Punjab and High Court has dismissed the SLP, but I will again humbly submit one thing there, sir. The only 3 lines are written by Justice Shah, sir, that this reply was considered and there is otherwise no error. So, as limited, I know, sir, it cannot be treated as a universal law that howsoever glaring patent errors are there, then writ should be thrown. Let me take a classical case, sir. If my assessee has already been assessed under 143 subsection 3 and now department is doing 148 in the new law, and that too without any fresh material and on basis of change of opinion, can it be permitted after Calvinated 320 ITR 561? The answer is no. And Supreme Court itself has said writ can be entertained in those cases where there is change of opinion, where already there is 143.3. I am telling you another glaring case, sir, because अभी जो 148 से हो रहे हैं सर, उसमें बहुत सारे केसेस में पुराना 143.3 भी कुछ केसेस में हुआ है, और जहां डिपार्टमेंट के पास कोई नया मटेरियल नहीं आया, फिर भी उन्होंने हमारा 148D का एडवर्स ऑर्डर पास कर दिया. वहां देयर कैन नॉट बी, वन कैन नॉट से इन ऑल माय हम्बल सबमिशन दैट यू रिट शुड नॉट बी एंटरटेन्ड. एंड अगेन देयर हैज टू बी केस टू केस फिल्ट्रेशन. As Justice Lahoti in a one judgment, I remember on Article 226, a landmark order, I learned this sentence from this phrase: a stitch in time could save 9. स्टिच इन टाइम कुड सेव 9, कि अगर आप टाइम पे स्टिच कर दो तो उससे बहुत सारी समस्याएं नो प्रॉब्लम को बोलते हैं वो सॉल्व हो जाएंगी. दैट इज जस्टिस लाहौटी's ऑर्डर ऑन आर्टिकल 226 इन सुप्रीम कोर्ट सर. सो इन माय रिस्पेक्टफुल सबमिशन 148 ऑर्डर कैन नॉट बी ट्रीटेड एज सच ए लाइट ऑर्डर कि दैट उसमें रिट ना एंटरटेन हो सर. दैट इज व्हाई दिल्ली हाई कोर्ट हैज एडमिटेड सो मेनी रिट सर.
He has admitted after 2-6 that was yes
सर.
वो
एक मिनट मुखी जी
वो
मैं माइंडिंग अप कर रहा हूं सर, मेरी फ्लाइट निकल जाएगी.
that issue has been liquidated.
मुखी जी सर आप मेरे से तो मैं बस वाइंड अप कर रहा हूं, आपसे इजाजत मांग रहा हूं.
that issue has been liquidated.
हाँ यस यस.
not waste time on that.
तो अच्छा ठीक है, बढ़िया है सर, अच्छी बात है. वाइजर विजडम प्रिवेल्स. सो आई वुड एंड मैम with a point which I was reading from Justice Rishikesh Roy's order. Again, you know, I love judgments and jurisprudence very much, sir. There is a judgment of Supreme Court in case of South Indian Bank, 434 ITR page 1 on section 14A by Justice Rishikesh Roy. And he has cited in the last paragraph, ma'am, the Adam on Wealth of Nations. And what Adam on Wealth of Nations says, there should be in all circumstances certainty from day one कि assessee को कितना टैक्स देना है, कब देना है और किस मात्रा में देना है अगर टैक्स सिस्टम को फ्लॉप करना है. तो ये मुझे समझ में आया कि जो जस्टिस ऋषिकेश रॉय के शब्द हैं साउथ इंडियन बैंक, और ये सेक्शन 14 है तो सर एक ऐसा सेक्शन रहा है जिसपे तो कभी सर्टेनिटी रही नहीं, और ये 148A भी कम नहीं है मैम उससे, और 270A भी मुझे लगता है कम नहीं होने वाला है. और संदीप भाई ने मुझे बोला था, मैं टॉपिक नहीं डिस्कस कर पाया संदीप भाई, 69C एक्सेट्रा 115 BBE बोगस परचेजेस. बट ये है कि ये सारी चीजें सर लॉ इवॉल्वेशन के फ्रेस में रहता है. तो मैं एक रामचरितमानस मुझे थोड़ा अच्छा लगता है, मैं एक लाइन रामचरितमानस की बोल के मैडम एंड करूंगा अपनी बात को. जाहे विधि होए नात हित मोरा, करऊं सुबेगी दास मोतोरा. थैंक यू.